It's an area that we've seen both Democrats and Republicans try to address in the past.
Should nonviolent offenders be able to own a firearm? That's now one of the questions state lawmakers will consider during the legislative session in January.
Now, in today's video, we're going to be talking about an en banc panel decision. I'll explain what that means here in a little bit. In a case out of the Third Circuit called USA v. Range. And it deals with nonviolent felons still being able to access their Second Amendment rights. It is not something that immediately is going to confer Second Amendment rights across all individuals in all jurisdictions. You know, they've been stripped of their rights because of their felonious status. But it is a major step forward. It also is something that creates a circuit split, which means this case is most likely ultimately going to wind up in the United States Supreme Court, where I believe we will get a resolution in favor of nonviolent felons being able to ultimately exercise their Second Amendment rights. All right, so a little bit about this case and sort of how we got here so you understand exactly what it means. First and foremost, you do need to understand that this case is not a final opinion. It is an appeal on what is referred to as a summary judgment. Now, I'm going to get a little wonky on you here, and I apologize for that, but I think it's important that you understand sort of procedurally the way that cases work. So when a case goes before a judge, one of the things that the defendant can do is ask for a motion for summary judgment. This essentially says, hey, even if we were to assume all the facts of this case are absolutely true, there is no conceivable way that the plaintiff could actually prevail. That, as you know, by law, they are precluded from winning. So when they have a motion for summary judgment, there's like a little mini trial, for lack of a better term, and the judge either grants the motion for summary judgment or dismisses it. In this particular case, Mr. Range had been convicted. Actually, he pled guilty to a misdemeanor about 30 years ago in Pennsylvania. Apparently, his wife had filled out a food stamp application and had put in some erroneous information. He signed this document, filed it, and was ultimately prosecuted for providing false information on an attempt to purchase or get food stamps. Now, while this was a misdemeanor under Pennsylvania law, it was a weird kind of misdemeanor. Typically, misdemeanors are crimes that are punishable by less than a year in jail. That's how most jurisdictions read them. But Pennsylvania is a little different. In Pennsylvania, it's punishment for less than 5 years. Now, under the federal statute, under 18 USC 922, it states that if someone has been subject, not actually, but subject to incarceration for longer than a year. So this would include certain misdemeanors like the one we're talking about here in Pennsylvania, then they are precluded for the rest of their life from being in possession of a firearm. We typically use the shorthand of calling this the felon in possession restriction. It's actually not an accurate statement. It's simply a subject to incarceration for longer than a year possession statute. That would probably be a better way of saying it, since after all, Mr. Range is not a felon, but he still falls within this net at the federal level. So in any event, Mr. Range is now precluded from owning a gun. And in fact, a number of years ago, apparently he attempted to purchase one and was denied. His wife thought, well, this must be some sort of mistake. After all, he's not a felon. So she ended up purchasing a gun for him. And it was a deer hunting rifle. Anyways, he used it and, went about his merry way, and then attempted later on to purchase a gun, and that was denied. This is when he first learned that he was prohibited from being in possession of a firearm, so he promptly surrendered the rifle that his wife had bought him a decade or so earlier. And then he filed a lawsuit seeking to challenge 18 U.S.C. 922, essentially saying that his Second Amendment rights should not be abrogated. After all, he's not a felon. And even if he were, he's not a dangerous felon. Well, in the motion for summary judgment, the state argued that under the Bruin analysis, Mr. Range is not part of the people. I'm going to sidebar for a second because I want to go over the Bruin analysis again and where the government has been putting a lot of their efforts. In the Bruin analysis, we start off with the plaintiff, in this particular case, Mr. Range, making an argument that his Second Amendment rights have been abrogated by the presence of the statute. Well, that's fairly obvious. He's not able to be in possession of a firearm. His Second Amendment rights have been abrogated. Then the burden shifts to the state, and now the state has to show how this law in question is consistent with our nation's history, text, and firearms regulatory traditions that existed in 1791, potentially also in 1867, but that's a topic for a different lecture. In any event, the government has been putting a massive amount of focus on step one. They kind of know that if the burden shifts to them and they have to show that there is a similarity of a regulatory tradition, there's a high likelihood that they're going to fail. So rather than deal with that, let's focus on, in their mind, let's focus on step one. And they said, well, Mr. Range, even though he is not, his Second Amendment rights clearly have been abrogated, he never had Second Amendment rights to begin with because the Second Amendment only applies to the people. And Mr. Range is no longer part of the people. Now, it's an interesting argument, essentially making the statement that the Second Amendment only applies to law-abiding people. Now, this is not the first time that this argument has been raised, and in fact, a lot of courts are extraordinarily dubious about this. After all, what is a law-abiding person? If someone has a speeding ticket on their record, are they no longer a law-abiding person? If someone is caught jaywalking, are they no longer a law-abiding person? And by definition, now, for at least these two examples that I've just cited, these individuals are no longer part of the people and ergo are not able to exercise their Second Amendment rights. You can see how this might be a little problematic. Now, at the other end of the spectrum, of course, we have dangerous felons. And maybe a dangerous felon or somebody who's a mental defective is no longer part of the people. And I say maybe because there's another interesting argument that starts to manifest. If they are not part of the people as it relates to the Second Amendment, then that begs the question, are they part of the people as it relates to the First Amendment or the Fourth Amendment or the Third Amendment to the Constitution? There's an interesting idea. Perhaps rather than having all these military bases in the United States, we could take the soldiers in these bases and forcibly quarter them in the homes of felons. After all, since a felon is no longer part of the people, they no longer have their Third Amendment rights to protect them from the forcible quartering of a soldier in their home during peacetime. Interesting thought. In any event, like I said, a lot of courts have been very antagonistic towards this, except, of course, in Mr. Range's case. The court says, well, yeah, okay, he's not part of the people, and therefore they grant the motion for summary judgment in favor of the government. This then gets appealed to the Third Circuit Court of Appeals. Third Circuit Court of Appeals has a 3-judge panel that continues to agree with the government's position, and they deny him his ability, or they don't overturn the motion for summary judgment. This then gets appealed to an en banc panel. An en banc panel is a larger panel of judges that now reviews the decision on the 3-judge panel. So typically most people think that goes trial court, appellate court, Supreme Court. That is true, but within the appellate court, there's two parts. There's, 3-judge panel, en banc panel, then you move on to the Supreme Court. In any event, last week we had a decision out of the en banc panel. There they agreed with Mr. Range. They said that as someone who was convicted, or in this case pled guilty to a non-violent crime that did have with it a span of time, potentially upwards of over a year in jail, they are still part of the people. And since they are still part of the people, they still have their Second Amendment rights. This has now been remanded back to the Supreme Court. The motion for summary judgment has been overturned, and now the case can move on to its trial. It's very likely that the government will appeal this now to the United States Supreme Court. So don't expect Mr. Range to have his trial anytime soon. It will be filed before the United States Supreme Court. Now, keep in mind that the facts of this case are very, very similar to a case that many of you guys might have heard before, and that was Cantor v. Ohio. Now, this case really came to prominence when Justice Amy Coney Barrett was going through her confirmation hearings. When Donald Trump appointed her to the United States Supreme Court and she was going before her Senate committee hearing, one of the things that obviously we were looking at was, has this woman written anything about the Second Amendment? And when she was an appellate judge, she wrote a dissent in a case when she was on a 3-judge panel. She wrote a dissent called Cantor v. Ohio. In that case, Mr. Cantor had been convicted. Actually, I think he pled guilty to mail fraud, felony mail fraud. Had to deal with the selling of insoles into shoes, which is, I guess, somewhat interesting, but not really germane to this conversation. In any event, he was now a felon, and as a result of 18 USC 922, he could not be in possession of a firearm. Well, he filed a lawsuit several years later challenging 18 USC 922. Interestingly, this lawsuit was filed before the Bruin case, after Heller, but before Bruin, okay? The 2 judges on the 3-judge panel said, I don't see what the problem here is. He's a felon. He's precluded from being in possession of a firearms. We're done. Justice Amy Coney Barrett, or at the time, Judge Amy Coney Barrett, said that she disagreed. And famously, she stated that the Second Amendment, at the time of the ratification, sound kind of like Bruin's analysis, that Mr. Cantor, at the time of the ratification, would not have been stripped of his Second Amendment rights. After all, there were individuals that had engaged in felony conduct that still enjoyed their Second Amendment rights. Now, arguably, the number was fairly small because most felonies resulted in capital punishment back then. But there were people that were felons that were still able to possess arms. The acid test wasn't whether or not they were felons. The acid test was whether or not they presented a danger to society. Were they violent felons? And Mr. Cantor, engaging in mail fraud, certainly doesn't rise to the level of being a violent member of society, someone who should be precluded from exercising their Second Amendment rights. So now, because of this Range decision that we've got out of the Third Circuit, we now have a circuit split. We have some circuits that effectively have upheld this felon in possession, or 18 USC 922. We have other circuits that have, like the Third Circuit, where they've said, no, this is unconstitutional. When you have a circuit split, that is usually a direct pathway to being granted cert for the Supreme Court to be willing to hear this case. They don't like having circuits that are split on constitutional issues. So I do suspect that this will be going before the Supremes. The Supremes will make their decision. And based on the makeup of the court and the way they've analyzed the Second Amendment, I highly suspect that individuals that have been convicted of non-violent felonies or subject to incarceration of over a year will have their Second Amendment rights restored. Okay, guys, so I'm pausing this video for just a moment. USCCA, which sponsors these videos, they are doing a giveaway right now, and it's pretty cool, but it does end soon. So you're going to want to jump on it. If you look down in the descriptions below this video, you can see a link to this giveaway. You're going to want to click on that. Definitely participate. All right, with that, let's get back to the discussion. Before you start sending me emails saying, can I go out and buy a gun now? I was convicted in 1972 of some nonviolent offense, felony. The answer is no. 18 USC 922 is still in existence, and it will continue to be in existence until we end up getting a final ruling on this. But it is a massive step forward, and good for Mr. Range. In any event, if you would like to email me, please do so at steven@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.